Good afternoon, ladies and gentlemen. Welcome to BW Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, we are going to discuss understanding the pharmaceutical IP and patent issues in India, considering India is the largest provider of generic drugs globally, and the Indian pharmaceutical sector supplies over 50% of global demand for various vaccines, 40% of generic demand in the US, and 25% of all medicine in the UK. It becomes important to discuss the challenges the sector may be dealing with. And to make this happen, we are joined by Ms. Mamta Jha, Partner and Head of Litigation, Intel Advocate, Mr. Divyam Agarwal, Partner, Jyoti Sagar Associates, Ms. Tusha Malhotra, Partner, Anand and Anand, Ms. Namrata Chatta, Partner, KNS Partners, and Ms. Aparna Karir, Partner, Ubhan and Associates. And I, Ashima Ori, Managing Editor of BW Legal World, have the honor of moderating this August session. Experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. So let's dive right into the conversation with opening comments from our panelists. I'd like to know your thoughts on the IPR laws for the pharma sector. How would you rate the legal environment for growth of the industry? We'll start with Ms. Jha. Ms. Jha, your opening comments, please.
Thank you, Ashima. I would like to thank you for picking up such a very relevant topic, which is very much required in this pandemic situation, vis-a-vis also a lot of ripples in the legal industry because of the recent judgments, in particularly in the field of pharma. I would say that we have long way to go. We have our legislation in place, uh, and that is quite robust. But somebody needs to put that into a dynamic and progressive way. Our Prime Minister talks about creating a healthy IP ecosystem, and we have national IP policy in place. But we have been talking and discussing about it, but the ground reality is still far, far away from that. Why I'm saying so? Because you'll see still today for patent in pharmaceutical field, which is I think the most important inventions for the mankind. This is the necessity. The way the environment is being compromised because of the advancement of like the lifestyle of people, the diseases are going far, far, far beyond human reach, and therefore the due importance which has to be given to the pharma industry and the invention therefore has to be in a manner where there is a sufficient motivation for the inventor to have the invention going and research and development going, and for the innovators to monetize it in a proper way. Otherwise, why will they invest? At the same time, a complete balance where it comes to a national emergency situation like COVID situation. There are enough mechanism where the general people and the mass health is not compromised. While we have the legislation in place, our Patents Act foresee all these situations, but in reality, it doesn't happen. So I would say yes, we need to have a more progressive environment. We need to have invent in India. It's not merely make in India, which is going to be sufficient, because make in India doesn't license you to copy and start manufacturing innovative product without getting into the having the involvement of R&D and creating yourself. So I would say yes, a lot is required to be done. We are far behind. If you take the global standard, it takes 5 to 6 years to receive a patent, whereas in most of the countries it is maximum 2 to 3 years. So we are lagging behind on the prosecution part. Even at the enforcement part, while we were settling the ground in a positive direction, the recent judgment of Astra, passed by Honorable Delhi High Court, has created a bit of doubt, and the ground has become very uncertain. So therefore, when I say that we need to have a system which have efficient prosecution, protection of patents, and enforcement of patent which has been granted. And I would say yes, we need to work towards that.
Thank you so much, Mamta. Thank you so much for setting the tune of the conversation with those insights. I move to Aparna. Aparna, welcome to the Saturday Solution segment, and your opening comments on the issue, please. Request you to unmute, Aparna.
I'm so sorry. Yeah. First of all, thank you for inviting me here. And as said by my previous panelists, I feel that India does have to work towards creating a balance in the IP world when it comes to pharmaceutical industry. While we do have robust laws in place, perhaps we have to look towards making a robust procedure and using them to the largest extent so that the pharma industry actually grows. And this pandemic has actually thrown open the world to the pharma industry and to all these issues that the pharma industry is facing in IP, and we have to work towards getting a balance and to see how best we can serve the world. India being one of the largest pharmaceutical producers in the world. So though we have the robust IP laws, but we have to still work towards them, and not only in India, but as a collective world as well.
Thank you, Aparna. So, we have robust laws. We need to have robust procedures. Tusha, do you agree? And what are your views on the legal environment currently?
I completely echo the sentiments of my previous panelists. Actually, well, I would though like to point out two very, very relevant things that although we have, as the Indian government, we have a dream for Make in India. Before we achieve that dream, I really would like to highlight that dream cannot be achieved if we are going to copy in India and not innovate in India. So that's one of the major hurdles that, both as a society or legally that we have to cross. We have the laws, like my previous panelist says. We have the laws to protect inventions. We have the laws to protect innovation or support innovation. All we need to possibly do is get down, read those laws in right light, and take the thing moving in the right direction. While one more thing that I'd possibly like to highlight in my opening round is that the pandemic has actually thrown one thing to all of us, which is while it is a real issue that there lies a public interest, and as real an issue that there needs to be an innovation to cater to the public interest. So I'm sure while we go along, there would be questions all of us would be addressing how to strike a balance, because both of them are absolute real issues and have to be addressed simultaneously, not one without the other. Thank you.
Absolutely, Tusha. Thank you so much. Striking the right balance is the need of the hour. Divyam, over to you. Your comments, please.
Good afternoon, everyone. Lovely to be the only male member on this August panel. Thank you, Ashima and BW, for inviting me. Picking up a cue from what Ashima said, according to Invest India, as of 2021, India is the largest global provider of generic drugs and houses the third largest pharmaceutical industry in the world. As the global market contracted due to the unique challenges presented by COVID-19, India's pharmaceutical exports grew by almost 18.7%, posting the best performance in the last 18 years. Such figures have perhaps been catalyzed by the numerous regulatory relaxations made by the government of India in wake of COVID-19 pandemic. As aptly pointed out by Ms. Jha, COVID-19 has resulted in a slew of litigations in the healthcare sector, spawning issues relating to medical negligence, securing supply of medicines and medical equipment, compensation to victims. Pleas seeking nationalization of the entire healthcare sector have also been raised, though rejected by the Supreme Court. I'm really looking forward to this discussion, discussing the legal landscape, pertinently the litigation trend and arbitrability of pharmaceutical IP disputes. Look forward to this discussion.
Thank you, Divyam. Thank you for sharing those numbers with us. And over to Namrata. Namrata, your comments, and do you agree with everyone on the panel?
Thank you, Ashma. Thank you for inviting me, and it's my pleasure to be with such esteemed panelists today. I completely echo with whatever the panelists have said, and taking forward from what Tusha mentioned, that there has to be a balance it goes out to see that, how complex the innovation is in the pharmaceutical sector. We have 4 clinical trials to pass. Every molecule that passes from each of the trials, ultimately, the preclinical testing, the number of molecules that goes on to start to the what is comes out and actually marketed is even less than 10% of what the industry started with. Similarly, when you go to this COVID vaccine, it takes 8 to 10 years to develop a vaccine in a normal course, and while we have come out with a vaccine in 8 months. So it's because of somebody invested into those R&D, into those innovations. And while as India, we of course we are the largest supplier of the generic medicine, and we have to take care of medicine access to poorer countries. At the same time, we need to strike balance and also acknowledge innovations. So that's all I would say.
Thank you, Namrata. I think what we're hearing is striking a balance. So we go back to Tusha. Tusha, could you just give us lay of the land as far as the scheme of the act goes, and what are the sections that you would like to start with?
So, what I'd like to actually start with when we speak about the Patents Act is, although the very name suggests that the statute protects innovations and protects a patentee, an applicant, and grant of rights. I just wanted to just set it right at the beginning before I go delve deeper in it. The statute actually sets out in great detail how the patent rights can be controlled and not misused, how a sort of a balance can be created, how public interest can be catered, and yet at the same time incentivize the patent, the whole regime. So to start with, I'll possibly start with the fact that we do have an expedited, and I'm going to leave this line of sort of developing law to the real practitioners on the side of prosecution. We do have very the provisions to expedite grant of a patent, and then how the patent is to be protected once it is granted. So application expedited levels at several places, at several instances, like you can apply for an expedited publication or an examination, which may result in an expedited grant. But although we are yet to see the real effect of it in real life, but as far as the protection of rights are concerned, which are once the patent is granted, we have strong rights, including going to court at any juncture after the grant of the patent to even get orders restraining copying of the patent or infringement of the patent. And our courts have repeatedly used such provisions. For example, Section 48, which defines the rights of the patentee, are very, very well read into and protected by the court. However, we do have certain instances where the court has refrained from protecting the rights. That being said, on enforcement, I would like to lay emphasis on a couple of relevant provisions under the Patent Act, which do pose as a challenge maybe to an applicant in the pharmaceutical sector, as well as a safeguard, so to say, in the pharmaceutical sector. Which, first of all, emphasis has to be laid on Section 3D. Which section? We've had a leading case in the Supreme Court, the Novartis case, where that section was interpreted and actually laid down as an additional layer of, a threshold that has to be crossed for grant of a pharmaceutical patent. So just to take a step back, for grant of a patent under the Indian Patent Act, there are 3 requirements to be fulfilled, which is novelty, inventiveness, and utility. Section 3D, it says, although for chemicals, but it has great applicability in the pharmaceutical sector, is the 4th layer or the 4th test which has to be met with before an application can proceed to grant in the pharmaceutical sector. So what that section essentially says is that, incremental inventions can be allowed. However, incremental inventions have to be seen in light of specific contours. So to say that, if it's an incremental invention, a requirement of maybe efficacy and enhanced efficacy from a previously disclosed pharmaceutical ingredient or substance has to be shown for an incremental inventive application to proceed for grant. So all those things being there, this is a relevant section, and we can actually take further questions as they are pointed, because it's a masterclass in itself on section 3D and unfolding Novartis, which really did happen very recently. So starting from there, I would mention that from Novartis, we've made a good headway in the direction of protecting patentees. We have had Novartis, when it came sounding like it's like an onerous obligation on the applicants or the inventors to overcome before their patents can be granted. Well, while we have gone through several years, 2014 till now, about 7 years, Novartis has been interpreted in a way that it can support incremental invention, which was the basic underlying idea thereof, was of that. Very recently, we've seen a judgment by the Delhi High Court by Justice Hari Shankar in FMC Corporation, which has decoded Novartis, and which says clearly that Novartis does not come in the way. In fact, it aids. It does not have to be interpreted so restrictively as interpretations are being afforded, but it's more like a word of caution rather than an absolute closure for incremental inventions. These are the things which have supported the industry, which have supported the very basic underlying idea of a support towards incremental inventions, which is recognized under our law. But like my panelist said in the opening session, that there is unfortunately a very recent judgment which sets us back. I'm sure she's going to delve much deeper into it. It sets us back in time, but well, I would say that it's sort of we are in a stage where we're going to go 2 steps forward and 1 step back, but we are going to get into the right direction eventually.
Thank you, Tusha. Thank you so much for setting giving us a lay of the land on the scheme of the Act. I'll now move to Aparna, and Aparna, taking from what Tusha has said, and we'd like to know further and jump right to the issues surrounding the pharma products in light of the provisions that we have in the Act. Now, where are the issues coming? So, your views on would love to know at a global level, what are we dealing with? India is going for waiver of IPR rights for the vaccines and emergency drugs for that matter. So what is the impact on pharma companies and your thoughts?
So I'm going to digress a little bit from my colleague there, and I just wanted to talk more about on the global level what's happening with the pharma industry. So as we are all aware, we are under one of the greatest health emergencies that perhaps all of us will face in our lifetimes. And the pharma industry has played a big role, and it's playing a big role in taking care of dealing with this health emergency. And they're providing us medicines, providing us vaccines, and as pointed out earlier, it's only taken 8 months for the world to see a vaccine. Now, when a company is investing so much in R&D, they of course want to get back something for the investment that they've made, and patents and IP is one way of protecting the R&D costs that they've put into all getting out these vaccines, getting us new products. And as earlier discussed, they allow others, the companies, to prevent others from copying their own products. So although patents basically restrict others from making the patented products. One other aspect is they can prevent dissemination of these pharma products. And of course, we've seen that recently. And according to Duke's Global Health Innovation Center, that's actually monitoring the COVID vaccine purchases, and I'm sure all of us are aware that all these rich nations have actually bought up mostly 53% of the vaccines, whether they're only a 14% of the population. And in fact, as you're aware, US, UK, and Israel has already started offering a third, booster dose. Whereas in India, once, we were all eligible for getting a vaccine, we all rushed to try to get in our slots. So, as you're all aware, getting a vaccine in India, where we are one of the largest producers of vaccine, was such a difficulty. This is in a country like India, whereas even lower developing countries such as in Africa, very poor countries, they perhaps will be the last to see a vaccine in their own country. So in this view, what India and South Africa in October 2020 had actually proposed to the World Trade Center that they waive certain provisions of the TRIPS agreement that takes, care of the IP protection in the world. And but however, as could be predicted, countries like Australia, Canada, EU, etc., had opposed this, and they had argued that TRIPS in itself has enough mechanisms to actually safeguard countries. And in fact, after that, this year on 5th of May, the US had actually also supported waiving of the intellectual property for COVID vaccines. And again, a number of countries have come ahead and supported it, but EU seems to be one of the countries that is still opposing it and restrictions. They do not want these waivers. And so I wanted to, just point out that these are some, debates that are going on at an international level. But how does it actually affect the pharma industry? Now, one of, the ways that it could affect the pharma industry would be that pharma industry may not be interested in going ahead and putting so much money in R&D when companies think that at a later stage, when it comes to making money, they will be preventing from enforcing their IP rights. So they may back out. And in fact, that's something that we need to look out for. And perhaps the better way out in terms of these waiver would be that all the companies come together, kind of form a patent pool, and work towards innovation and work towards providing the entire world with not only the patent rights, but the know-how, how a vaccine is produced. In fact, something that I wanted to point out was, although companies have said, and specifically Moderna has said that they will not enforce their patents against the vaccine, but because know-how is not present, it's not easily available, nobody else has been able to replicate the vaccine. Perhaps it's time for us to think out of the box and not just look towards waiver, and try to come together and not only help the innovator companies in R&D and by maybe applying for licenses and coming together with licensing pools, so that at the end the entire world is at a benefit. So this is all from my end.
Thank you, Aparna. I would just, like you to elaborate a little bit on the waiver that we are seeking. What is that India is really wanting in terms of the waiver of the IP rights there?
So under the TRIPS agreement, you prevent others from enforcing on your rights. So India is trying to actually seek a waiver so that on these vaccines companies do not enforce their patents for some of the vaccine products. So these are the waivers under sections 1, 4, 5, and 7 of the TRIPS agreement that India would want the waiver against.
Thank you, Aparna. Thank you so much for adding that. And now moving to Mamta. Mamta, we've jumping back and forth just to be able to cover multiple dimensions of the conversation. But once again, taking from what Tusha had mentioned, that's one of the concerns. Again, one is at the global level, but again, Astra judgment is yet another concern. National patent policy and hindrances in R&D and investment. These are all words that we've heard throughout the conversation so far. Would you please elaborate on how this is actually impacting the pharma industry?
Sure. So just taking the previous question, that the landscape, because we are discussing about balancing the rights of a patentee as well as the public interest and the public health. So if you see the scheme of the Act, right from patentability, there are several criteria and specific criteria laid down. And as Tusha has rightly said, Section 3D, which has been the extra layer for pharmaceutical patents in particular, and that has been expressed by Honorable Supreme Court. Thereafter, not only the rigorous examination, there are another layers. So 25(1), which is like pre-grant opposition. Then once the examination is completed, your patent is open for anybody can file opposition to. So you go through the pre-grant opposition. Once it is granted within 1 year, you have a scheme of post-grant opposition. So again, your patent is susceptible to challenge. But once that period is over, and then when the patentee is granted patent after like 7-8 years, at least in India, and marketing approval takes another 3-4 years, which is like 12 years has already gone. The innovator is only left with 7 to 8 years to monetize whatever. And I think Aparna was totally right that when you make so much of investment, why are you making investment? You have to, nobody realizes that out of one molecule or one invention comes out, there are 50 failures where you've already invested and the failure doesn't see the light. So therefore, there is a scheme of the Act. Once the patent is granted, it has already gone a rigorous examination and enough opportunity to public to object and lay their claim that this is not patented. Now the situation comes when the patent is granted. Now once the patent is granted, it's very easy for any generics company. Oh, now the approval is granted. It is a successful product. Now I will start thinking to launch my product. But there is a mechanism even after that. You can file revocation. You file revocation, have it cancelled, and then you launch the product. But that fair play is lacking. And therefore, we need an ecosystem where the clear message is said, see, you are under your right to challenge the patent, and you have been given enough opportunity within the Act. Pre-grant opposition, post-grant opposition, revocation. Please exercise that. But you can't launch at risk and then argue reverse, no, your patent is incomplete. I agree that there is a mechanism provided under the Act where counterclaim can be raised, but there are judgments where it has been said that it will not be right that you have not cleared the way. So generics, see, it's a business ground. IP is all about creating the business opportunity and monetizing your business through your IP too. But if you don't create that IP ecosystem, legislation is there, enforcement mechanism is there, but the outlook has to change. The business manner and the approach has to change if you have to really make India as a ground for global investment. Otherwise, we will all be talking and not be progressing, not be inviting. See, it's a prime time when people are moving out of China, and I don't need to elaborate on that. And India is a very, very fertile land, inviting all those investors to make investment in India. Now, if you don't provide that IP healthy ecosystem where the rights are balanced, then you will probably lose this very, very critical opportunity, which is available to you and may not be available after 5 years. So the point I'm trying to make is this: in pharmaceutical and patent landscape, there is enough mechanism which has been provided under the Act. Coming back to public interest, there are provisions under Section 83, 84, 92, which is national emergency. The government can actually put to use the patented product and compulsory licensing and so on and so forth. And TRIPS is already there, which Aparna has rightly said that, that waiver discussion is going on. So there is a mechanism to address public interest, but you can't use the plea of public interest. Pandemic is one situation, but you can't apply to all other pharmaceutical, like enforcement action and say, no, since I am generics and price difference and it is in public interest, but why were you sleeping? If you were interested to take advantage of the invention, or you believe that it is not a worthy patent, it has to be, revoked, then you had all the opportunity right from pre-grant to post-grant to revocation. You don't have to copy and then argue all this. That is where the imbalance is becoming critical. Because, and coming back to Astra judgment, and I agree with Kusha, we go 2 steps back and come one step forward. But the timing is not correct. This is the timing where, India is at the most leveraging position. When everything, the entire global environment is such that you can monetize, you can really attract business here. At that point of time, when we already had judgment, we moved from Novartis Supreme Court judgment till from Roche Shipla to Merck Glenmark, we settled the ground. Astra judgment has maybe temporarily unsettled it to the extent that it says now the inventive step for the inventor, if the inventor is the same, the criteria changes from where we are getting this. In the entire world, this is not the criteria. So, and from where it is coming, it's not even under the legislation. So the point I'm trying, and also kind of the Marcus claim, which is patented worldwide, even the patent manual of Indian Patent Office recognizes Marcus claim. The genus and species inherent because of Section 3D. Otherwise, what Section 3D says? Section 3D says, if there is already a known substance and a derivative thereof is discovered, you need to establish enhanced therapeutic efficacy. What does that mean? There is already a known substance, which is genus. There is a derivative, which is a species. So the recognition has been given under the Patent Act, under Section 3D, but Astra judgment point blankly says, we don't recognize this, then this is a serious problem. So therefore, what I'm trying to say, I agree with Kusha, things will move on because we can't be, if this judgment becomes final, I'm sure the entire IP policy, national IP policy and the government mission that invent in India, innovate in India is a farce. So it will be set right. But having said that, this timing is getting lost because of this judgment is my concern.
Thank you, Mamta. Thank you so much for elaborating on the various pain points the industry is dealing with. And coming back to Tusha now, Tusha, Mamta has echoed your sentiment and also added so many more points. What is, what are the other pain points in the industry? Some time back, I think when we were discussing, you also mentioned blacklisting of some of the, past sanctions by the US and blacklisting by the US as far as India goes. What was that about? Could you please tell us more?
So let me just, before I address directly about the pain point which you have identified clearly, I just wanted to add a couple of more points from my previous panelist, Mamta, that, it's a fact. It's an economic ecosystem that has to be built. Unfortunately, while we have appreciated that there is enough safeguard under our act, we balance rights, we give incentive to the invention if read right and interpreted right, the act provides for it. There are a couple of things which actually have now become pain points in the Indian system. Is first is how the time lost in getting approvals is not compensated. In various countries of the world, what is called as a patent term extension, which is especially focused on the time lost in getting approvals, marketing and drug approvals and clinical trials performed for them, is compensated by the government, so that the costs that have gone in or the investments that have gone in, there is an opportunity to recoup that by the companies and further invested in further research and development. So that certainly is one pain point. The other pain point, it's sadly enough, it doesn't even arise out of our Patents Act. It's basically our other procedural, like Code of Civil Procedure and Evidence Act, that whatever a pharmaceutical company, the statements that they may have made under in different jurisdictions under the jurisprudence of that jurisdictions, they've been read out of context and they've been considered as admissions. Well, nothing is being provided under the Act for such admissions, at least the Patents Act. Nothing is provided, and our courts are repeatedly sort of interpreting those statements which are technical in nature, which are made specifically pursuant to specific regulations and procedures of a certain country and the laws in that country. They are being considered as admissions. I mean, a question of technicality. When we talk about patent, it's unfortunately a deep question of science and technology. Such questions are briefly being answered on the basis of admissions, which certainly is one big pain point, which is definitely not only coming in the way of grant of patents, it's also coming in the way of honoring our commitment to incremental inventions, which is under the scheme of the Act, as well as attracting, coming in the way of attracting what the world would or could have, at least in the present circumstances, as Mamta has previously pointed out, to come to India and invest in India. We are missing that out. Going from here, now coming back to the pain point that you asked me, we had almost reached a stage of being blacklisted by the US, or trade sanctions being applied onto us by the US, which would have definitely impacted economically our entire, economic ecosystem. Fortunately, it didn't reach that stage. Right after Novartis, there is a special 301 report that the Office of US Trade Representative, which is called as the USTR, publishes almost every year. Right from 2014, India has been on the priority watch list of US. It reached a stage where US sat down for discussions of, while discussing other treaties, that pharmaceutical companies may also actually sue the Indian government for not honoring and committing, honoring their commitments on return on investments and their bilateral policies and things like that. Fortunately, didn't reach that stage, but still, as of 2020, the very recent report, we continue to be on the priority watch list. For actually not showing, over a period of 7 years, not showing enough progress in terms of development of patent law or improvement of regime to honor and to protect genuine innovation. I mean, genuine innovation, genuine inventions are not being recognized just because the way few judgments have interpreted the Act, and very recently the Astra judgment, like we said, going 2 steps further and coming 1 step back. So we are still struggling in that domain, and the world has taken notice. US being one of the important trade countries for us has taken repeated notice. So it's about time that everybody, I mean, the regime in India is started to go in the right direction without further hiccups and gets settled soon. So.
And what are your thoughts on the enforcements of patents in India? If you could briefly know, we've heard at a global level how we are being monitored for our, not so progressive attitude towards securing genuine innovations. But what is happening in the land?
Well, I carry a very balanced view here. I don't think it's absolutely anti-enforcement or an anti-patent protection regime that we are into. While there are hiccups that we are going through very recently in Astra, our courts have, after Novartis in the period of last 7 years, our courts have started, protecting the rights of the patentee. They grant more injunctions than deny as of today. So that's how I started. I beg to differ a little bit. Yes, we have scope for improvement, but we are consistently improving in terms of enforcement as well.
Thank you so much, Tusha, for shining light in that on a positive note. And over to now Namrata. Namrata, inviting your views on what we've heard so far, anything you'd like to add, and also what are your views on, as we discussed with Aparna, the waiver of IP rights, and what is the solution for actually balancing the public interest vis-a-vis the interest of the pharma companies?
Thanks, Ashima. I agree with the panelists, the views they've put forward, and there have been some really fascinating pointers, and I'll actually take up a cue from them. So, the whole discussion around IPR waiver, it began when India and South Africa put forth a proposal, as Aparna also mentioned. While the proposal was for the waiver of all the IPRs that are covered under WTO, the mainstream media is only discussing about the patent waiver. So they carry an image of that the patents are the culprit everywhere. And, even United States, although supported the waiver, what they did was that they supported a waiver on text-based negotiations, which meant a very long process, and only on COVID vaccines patents. Again, the whole focus was shifted. So while the discussion around this patent waiver actually took away the focus of the nations from the real and the immediate problem. The real bottlenecks were really different from the patent or the hindrance caused by the patent. The real bottlenecks were, as Aparna also mentioned, the know-how. Was there anyone who is ready to transfer the know-how? The patent only discloses, it does not really includes the actual way of making the product, whether it is vaccine or it is any other pharmaceutical product. So, for example, for a Pfizer vaccine, they themselves mentioned that it takes about 280 components to make the Pfizer vaccine, and it involves around 50,000 separate process steps. So who is ready to transfer that know-how to each of those companies who are willing to produce it? Again, are there enough trained technical personnel who can actually make the vaccine, given that even the know-how is transferred, even if that is done? Is there sufficient raw material, which is there available? So the Serum Institute during April or May somewhere mentioned that they were short of the raw material, which was being supplied by US, because US put some export trade restrictions on them, because of which they were not able to get this raw material, and subsequently the vaccine manufacturing was stopped. So is there enough raw material for production of these vaccines? Any error in vaccine production, by a third party, who is responsible for that? It can bring a huge impact on the reputation of the pharmaceutical industry or the innovator who's actually done so much of R&D. We have newer strains coming up. A lot of panelists have discussed, how do we encourage innovation? Who is going to invest in it if the patent rights are not protected? And it's not just about vaccines. I'll say that again, it's about any pharma drug or for any pharmaceutical product that comes into market. Mamta spoke about, pricing issue and the public policy coming in. So I'll just give a quick example. It was very fascinating to see for me also. The vaccine that this Pfizer is selling in the African Union, they're selling it at USD 6.75 for one dose. In US, they're selling it for USD 19. Now, India, for its own homegrown Covaxin that we have, they are selling it at a cost of around US INR 1400, which comes out to be around USD 18 or 19. So India is selling it at USD 19, and Covishield, which is being developed with AstraZeneca, is being sold about USD 10 per dose. So the Indian government itself believes that the pricing of USD 19 and 10 per dose is, it's respectively reasonable. So it's pretty reasonable. Then how does the medicine access to the poorer nation comes into picture? So it's a very political stand. It's a very I am nobody to say whether this IPR waiver should happen or not. But yes, I feel that India should focus more on maintaining a balance between its position that on access to medicine, as well as the spirit of the national IPR policy that promotes innovation, that promotes protection of IPR. As Tusha also mentioned, we are always on the watch list of USTR. And while we want to increase trade, we want to invest, we want companies to invest in our country and bring up innovation, we need to maintain that balance. We need to find out alternative solutions. We need to encourage licensing, voluntary licensing, and other means to make this accessible more to the patients.
Thank you, Namrata. Thank you so much for adding those points there. And you mentioned taking from there and moving to Divyam. You mentioned where does the liability lie when there's an error in making some of these drugs. So Divyam, what are you seeing in terms of the litigation and dispute when the disputes landscape when it comes to the pharma companies, and what is the real need that needs addressing right now?
Thank you. So, as mentioned by Ms. Jha, we need an ecosystem which allows fair play. In my view, arbitration is one mechanism which can assist pharma companies to enforce these IP rights. But for that, we need to understand the arbitrability of IP disputes. The general rule is that rights in rem, that is, rights applicable against the world at large, are not arbitrable. Accordingly, disputes relating to grant or registration of IP, declaration of validity of IP rights have been held to be non-arbitrable. However, this rule does not have a blanket applicability over all disputes involving pharma patents and IP rights. Rights in personam, that's rights against a particular person or a party, have been distinguished from rights in rem. Recently, in a judgment passed by the Honorable Supreme Court of India in a decision of Vidya Drolia, they comprehensively engaged with the contours of arbitrability, while setting out a fourfold test for determining whether a dispute is arbitrable or non-arbitrable. The Apex Code noted, insofar as the non-arbitrability is concerned, that disputes relating to actions in rem that do not pertain to subordinate rights in personam are non-arbitrable. Thus, the Supreme Court drew a distinction as to the arbitrability of actions in personam, even where it arises from the rights in rem. This, in fact, reinforces the position as has been adopted in several decisions of high courts in Eros International, Lifestyle Equities, Hero Electric Vehicles, that though disputes regarding grant or registration of IP are not arbitrable, disputes as to the infringement or licensing of IP, being actions against particular persons and not against the world, would be arbitrable. So it's very important that if there is any arbitrable issue, then the right ecosystem for that would be arbitration. Another issue which you dealt with other panelists, and I just want to touch upon, is that pharmaceutical industry grapples all the time with, and is in fact often accused of patent versus patient regime. So it's important to understand that where the pharma industry is coming from, and is there any steps being taken towards that. Even results on account of COVID-19 are no different. The government of India has in fact adopted a welfare-centric position in the international domain, at least, having floated a proposal before the BIPO, as pointed out by one of the panelists, which is WIPO, in fact, has created a technology access pool to hasten collaboration with COVID-19 resources. In fact, closer to home, both Delhi High Court and the Supreme Court of India have urged the government of India to exercise its powers under the Patents Act 1970 to grant compulsory licenses for various drugs required for the treatment of COVID. Though in an affidavit filed before the Supreme Court, government has stated that such use of powers may be counterproductive and have adverse unintended consequences. Nevertheless, the public interest continues to be held in high regard, with the judiciary emphasizing the subservience of private commercial interest to public good. Speaking from the pharmaceutical industry side, the industry is alive to the overarching welfare motive. Their role in the battle against COVID cannot be gainsaid. They have, in fact, moved to collaborate and create treatments quickly and effectively. In fact, the voluntary royalty-free licensing of baricitinib is just one such example. Despite all these disruptions, pharmaceutical industries continue to provide the supply chain and provide all these essential drugs, which really helped us in sailing through these positions. So all in all, I would say that if there is an ecosystem that needs to be developed, that needs to be developed at the end of the judiciary. They have helped out in developing insofar as arbitrability of IP disputes are concerned. And as I hear from the panelists, even hopefully the AstraZeneca approach would be changed. There is a room there, and if there is any light at the end of the tunnel, we'll hope to see more robust judgments from the judiciary to come up with some legislations to protect the general overarching IP rights as well.
Thank you so much, Divyam, for adding that patent versus patient, remark there. And then that is actually something that we hear a lot in the industry. I invite now closing comments from everybody. We wait if any participant wants to add any questions. Participants, audiences, if you have any questions, please write to us and we will take them to our experts. In the meantime, we invite the closing comments from our experts on so many inputs have come from across the board. How steep is the road to implementation now? What are we looking at, even if that means setting aside of some of these error judgments? What are we looking at going forward, and what would be your one wish for the pharma industry right now, or the IP landscape right now? Starting with Mamta.
Thank you, Ashima. I think, as I said, balancing is the key, and therefore the outlook of generics industry, the outlook of innovators, or other side of balancing, that you make the drug available and reasonable price, and all that thing, and the outlook of enforcement and protection. The everything has to change, keeping in mind that these IP tools are very valuable from the economic growth of the country. So that needs to change. Otherwise, in terms of legislation, we already have everything. Some of the points which I agree with you, like Namrata made a very good point, that when you sell a drug internationally, you don't think about price, you are monetizing. Then how you can come and say that, public interest becomes my defense and India is a poor country? So that needs that. It's nothing, but it's just the outlook. You need to have a consistent position internationally as well as in your country, inspiring confidence and motivating innovators to innovate in India and investors to bring their product and patent in India. That will be the one comment which I have. Thank you.
Thank you, Mamta. Thank you so much. Aparna, over to you, please.
Thank you, Ashima. Going forward from what Mamta said, I just want to add one comment, is that we should look for consistency. Consistency from when the patents are filed, how they're prosecuted, what the patent offices throw at you, consistency in their decision, as well as perhaps consistency across the jurisprudence, so that the industry, the people involved, everyone has an idea and they know what is coming. So perhaps AstraZeneca case put us back because it went against the consistency, and perhaps that's something that we should look for and work towards.
Thank you, Aparna. Thank you so much. Tusha, over to you, please.
I would not repeat what my earlier panelists have said because I thoroughly agree with it. I just would possibly add to, saying that although it is, we see it as an economic ecosystem, it is about investment and return of investment. But we also need to see it as, working in the interest of public. And the interest of public cannot only be catered by cheap medicines. Well, we have to be aware of the fact if there are no medicines, the expense or the cheapness of it is irrelevant. We have to possibly join hands together, the judiciary, the Indian companies, the innovators, like Divyam quoted that example of when it was a time of need, baricitinib was, included in the COVID therapy in India. Eli Lilly went out and gave voluntary licenses, royalty-free royalty licenses to a lot of players so that, the supply chains are maintained. At the same time, the generics should also possibly practice a bit of caution instead of infringing, collaborate more, work in the direction of research more, and the judges to possibly, help aid such ecosystems so that in real sense, public interest can be, met with. I'd also like to add, we do see the big pharma as, I don't know how to explain. I don't want to use any adjective there. So we know the word, the very term big pharma invokes a lot of emotion. Well, that's not entirely true. Unfortunately, there are practices that the big pharma has adopted with specific India related specifications. For example, there are cases of differential pricing. Like Namrata mentioned, for the vaccine in India, it's a higher price than what is being exported to the Africa. Likewise, the international or the big pharma has seen, those innovator companies has seen the spending capacity of India. They've done research. They've launched their medicines in India. To at a differential price. They are way cheaper than what they are in the US and the homeland. We need to respect such endeavors and encourage such endeavors by at least protecting their rights. So the idea is to work together and go in the right direction so that in essence public interest can be met.
Absolutely. Thank you, Tusha. Namrata, over to you for your last comments on this.
My wish would be that it's not difficult to coexist for the innovators and the generics. And, every day, if I prosecute a patent, my practical wish is that the examiner sees it through the eyes of the innovation and not through the pricing or the public policy. There are provisions and acts and legals. There's drug pricing controls. There's competition law. There is a lot of other provisions, and even within the Patent Act, there is compulsory licensing. If tomorrow the innovator is not able to provide the drug in enough amounts or at an affordable pricing, there are always provisions for the government or other companies to invoke. Today, you look at from the eyes of innovation, from the law that I am required to comply, and not always through what has been set up by Novartis judgment. So that's how I concluded.
Thank you, Namrata. Thank you so much. Divyam, any additional points that you'd like to make?
I just would reiterate that a lot hinges on adequately balancing public interest against private rights of the pharma industry. While the public interest is paramount, the industry cannot innovate without any reward. So balance is the key. And as rightly pointed out by the panelists, that we, apart from the balance, we really need to be consistent with our approach. That's about it.
Absolutely, Divyam. So thank you so much, panelists, for sharing all those thought-provoking instances with us and your valuable inputs. What we hear is that our innovators are getting ignored in the interest of public demand. So we hope the balance can be struck as soon as possible. And thank you so much for joining us today with these lovely thoughts. Thank you so much once again.
Thanks,
Thank
Ashima.
you.
It's been an absolute pleasure being here with all my panelists.
Thank you, Tisha. Thank you so much.
Thank
Very
you.
good initiative. Thank